So Dan, for the corporations, business owners out there, future business owners, could you talk a little bit about how we're, changing title with, companies and how that process works with the living trust, just to help us, out there on what that really means when you have a corporation?
Yeah, the problem with businesses is when we think about our assets, for some reason, businesses are often overlooked a little bit. When we say create your living trust, make sure your house and your properties are in the trust, make sure your accounts are in the trust. We also mean make sure your business is in the trust, because the business, if it's not formally transferred to your living trust, it can and will go through probate court, which will be a very public affair, expensive, and control of the business will fall to the court. I mean, you'll have a judge running your business if you don't properly plan for succession. So yes, definitely, it's very important. If you have any kind of the standard businesses, and let's go through them: corporation, LLC, partnership, or sole proprietorship, a fictitious business name, just a DBA, even if you just have a lowly, humble DBA, any one of those four types of businesses should be put into your living trust. And the way to do it, one way to do it, is to just do a business assignment. Oh, it's a written document, and it says, I hereby assign all my interest in ABC Accounting Corporation or ABC Pool Cleaning Service, whatever your business is, to my living trust. And that piece of paper acts to transfer not only the ownership of the business, but all that the business owns. So if your business owns cash accounts, receivables, equipment, inventory, buildings, furniture, vehicles, that simple assignment will transfer all of those things in one fell swoop into the trust, and all of those items then are in the trust, and they will be protected from going through probate. So people also ask me, well, if I put my corporation into the trust using an assignment, do I then have to go change the bank account at the corporation bank account at the bank into the trust?
Sense.
And of course the answer is no, because if the corporation that owns the account, the whole thing went into the trust, then the bank account's already in the trust. The bank account's still just going to be in the name of ABC Accounting Corp, or whatever the name of your corporation is. So the building that the company owns isn't going to change. The title won't change. The ownership of the bank account that the corporation or LLC or partnership owns, that's not going to change, because the whole business was placed into the trust properly, hopefully, by creating and executing a business assignment.
So Dan, one of the things, we talked about, property and grant deeds being transferred. What type of steps are in place for businesses, and what do we need? Does that still go to the recorder's office? What's that process, and what happens if you have multiple businesses or a DBA under, maybe you have one corporation but they're acting under vehicles? What's that process there?
So the document is it's a business assignment. If it's a corporation, it's a stock assignment, assigning the interest of the stock into the trust. If it's a limited liability company, then it's an LLC assignment into the trust. If it's a sole proprietorship, then it's a sole proprietorship assignment into the trust. So yeah, it's a written document, but the difference, Chris, is it's not publicly recorded. It's going to be kept in the papers. It could be in the corporation book, if you have a book that you keep your corporation documents, your articles and bylaws and stock certificates. All of that should include the stock assignment that transfers the stock into the living trust. And that's how it's done. Now, another way you can do it, if you want to do it on your own, you can actually go to the back of your corporation kit, and usually at the back, that's where all the stock certificates are.
Okay.
And you can take the stock certificate that just says your name, 10,000 shares, and you turn over the stock certificate. On the back, there will be a legend, and you endorse that, and you surrender the stock certificate back to the company. Let's say that's stock certificate number 1. You surrender number 1 certificate back to the company. You enter it on the stock ledger, and then you reissue yourself stock certificate number 2 for the same 10,000 shares. Only stock certificate number 2 is going to say Tom Jones, if that's your name, trustee of the Tom Jones Trust, dated July 4, 2023. So you can affect the transfer of a corporation and all that corporation or LLC owns by doing an entity assignment into the trust, which is not recorded, or you can actually get into your own paperwork and reissue yourself the stock or membership certificate. Most people don't like to do that, and most people can't even find their book.
Yeah.
So that's
yeah,
why,
exactly.
that's why we do the stock certificate assignments or LLC assignments is because people don't want to be bothered with the minutia, and they won't follow through. And at the end of the day, if they pass away, finally we'll find that book, the corporate book, buried somewhere in a box or covered with dust, and we'll dig it out and we'll look at the stock certificate, and if it doesn't have the name of the living trust as the owner, then that company could be headed to court, where the court will start to manage your business. So we don't want the government to manage our business at all, and that's why we use a living trust to prevent probate and to preserve privacy.
And Dan, what happens if you have an ownership interest or stock in a corporation, not maybe like a global, big global corporation, but let's just say there's 3 or 4 partners. Can we do multiple trust with that company going through a similar process, or just my share? I want to make sure. Does that get a little bit trickier for the multiple partners?
What you're talking about, Chris, is business succession planning, and it's a big part of estate planning. Business succession planning involves planning the estates of all of the partners. So let's say you're proactive, you're a smart guy, you create your living trust, you do a stock assignment, and you transfer your 1/3 of all the shares into the trust. So you're good. If you kick the bucket, your share is going to go to your beneficiaries. But if the other 2 partners die, they're not so smart, they didn't get their living trust done, their shares are going to go through probate.
Oh, wow.
So now you, as a surviving partner, are in court because your other partners were lazy and didn't get their trust done.
Wow.
Or unknowledgeable. So yes, the answer is yes. If you have 3 partners, all 3 partners need to have living trusts and assign their shares into their trust so that nobody is going through a probate if another partner dies. That's step 1, just avoid probate. And that's pretty basic, right? But step 2 is, let's say if you pass away, well, let's pick on partner X. So let's say partner X is married and his spouse or her spouse doesn't know anything about your business. And let's say partner X even has a living trust, and his trust leaves everything to his wife. Now partner X dies, everything goes to his wife. Your partner then becomes the wife. You are now in business with your deceased partner's wife.
Interesting.
Which might not be a bad idea if she's great and he or she is great as a spouse in running the business, but most spouses do not share the same profession of their deceased spouse. They may not be a doctor, a lawyer, an engineer, a dentist. They may not have the qualifications or the abilities to run a steel company or a car dealership or whatever it is. And so most spouses just want the value of their deceased spouse's share. They want to be cashed out. So that way they can go on and live the life that they're accustomed to and want to live. And now you and the other partner, remember there were 3 partners, so one died. The spouse got the stock through the living trust, but she doesn't really want to be involved in the business. So what you really want to do is give the spouse the money, and then you and your other partner split the remaining shares of the deceased partner. And we do that with what's called a buy-sell agreement. So buy-sell agreements combined with a living trust are the best way to kind of structure the business succession planning. And that's really a topic for another day.
Yeah.
We'll have to talk
about, sounds like it gets more technical.
Business succession planning. But the very first step is, which is what we are talking about today, which is just make sure your business, whatever kind it is, corporation, LLC, partnership, or sole proprietorship, make sure it's in your living trust so it doesn't fall to the court to run the company. If it's in your living trust, your successor trustee can continue to manage the business, or they can sell the business or distribute the business based on your instructions, and they can do that privately without any court intervention.
And Dan, is this something, we got into some really technical, matters about this, but is this really easy to do with, modern trust? And
well, modern trust is easy to create the trust and to transfer your properties, your businesses, and your accounts into the trust. Sophisticated buy-sell agreement between mutual partners for a corporation is something you need to find an attorney and structure properly.
So the first step, at least, can be covered really quickly by getting the trust, getting your estate plan, getting the business in there, and then there can be some more steps after that a lawyer or somebody can help with.
Yeah, business succession, we'll talk about that again. It often involves insurance on each party's life. Like if you're going to cash out the spouse, where does that cash come from? Well, usually it's a life insurance policy that all three partners have been buying over the years. And so when it's properly structured with plenty of forethought, it works beautifully. But the first step, as we talked about today, is make sure your business is in your living trust. You'll regret it if you don't. It'll be very expensive if you don't. And that old saying, an ounce of prevention is worth a pound of cure. Doing one simple stock assignment for your interest in that company is definitely easier than going through probate court for 2 or 3 years and paying 8% of the value of the company to the lawyers in the court. Could be tens of thousands or hundreds of thousands of dollars versus $100+ to get the whole thing done correctly. So an ounce of prevention is worth a pound of cure.
Wow. Well, can't wait to talk more about business succession and planning and tying that in with estate planning. Sounds like a fun topic, Dan. Thanks for all your advice.
It's all fun. Talk to you later, guys.